Legalese. We've all heard it, seen it. Most recently, I saw this meme, which was absolutely hysterical and very accurate. But on top of being a little silly and the butt of the joke, often rightly so, legalese can also be a really important way that people in the legal profession communicate with one another. Ironically, it's often built for clarity, and so when you go to law school, you're bound to find it everywhere. Rarely, though, is it going to be explained to you. When I started law school, I was advised to buy Black's Legal Dictionary, which I refused to do because I didn't need to double my reading time. So I thought it would be a good idea today to make a video explaining to you the most commonly used and, in my experience, least explained legalese terms. First is plaintiff and defendant. Very simply, these are the two sides or parties to any case, be it civil or criminal. In a civil case, the plaintiff is the person bringing the suit and the defendant is the person, well, defending themselves in the suit. In a criminal case, the government is always going to be the plaintiff, and they'll rarely be referred to as such. It's usually just government or state or people, the insert defendant's name here. When a case is appealed, though, to a higher court, meaning that some finding has ended the case in the lower, usually district court, the parties are referred to as petitioner and respondent, and they can flip back and forth depending on how many times it goes up and down the chain of courts in the appeals and rulings. Petitioner or appellant is the person appealing the judgment, and respondent or appellee is the person responding to it. Some of these are pretty common sense. Now we're going to get into some Latin terms. Maybe you've heard them before, maybe you haven't, but they are really important and used all the time. The first is stare decisis, which essentially means to stand by things decided. It refers to the principle that where cases are similar, either factually or legally, that the court is going to defer to precedent, set either by that court, an equivalent court, or a higher court. This often overlaps with what is called mandatory authority, which means that the judge doesn't have a ton of discretion in how to rule on the case because they need to follow the rules that have been set out for them before. Persuasive authority, on the other hand, can come from equivalent courts in different circuits or states. We'll get to circuits later, don't worry. Or something decided in a lower court. So if you have a case in the Court of Appeals, something from the district court or a different court of appeals would be persuasive authority, while rulings from that Court of Appeals or the state's Supreme Court would be mandatory authority. Next is actus reus and mens rea, which are the two types of elements defined in criminal statutes. Pretty much every crime is going to have an element for actus reus, which is the actual act of committing the crime. You can't really be punished for something you didn't do, but sometimes that's not enough. Many crimes have a mental element, or the mens rea, saying that in order to be proven guilty for that charge, you have to be proven to have done it intentionally or knowingly. Your criminal law professor will probably explain these to you. If they don't, they're not a very good professor. But I think it's a helpful thing to know beforehand as well. Something that may come up in criminal law or any other area of law is the distinction between de jure and de facto. De facto is just like it sounds, it means in fact. So what are the legal practices that are actually being applied, regardless of if they are strictly legally recognized? De jure practices are those that are legally recognized, whether or not they are practically enforced. For example, for a long time, and maybe even still today in some states, adultery was a crime. I don't think there's a single place left in the United States that would actually throw anyone in jail for doing this though, which means that while it could be and has been law de jure, it is no longer law de facto. We're going to move on to a really big subject of law that I cannot cover in full detail right now, and that is the burden of proof. There are different burdens for different elements of the legal process. The most important ones are beyond a reasonable doubt, which is the burden of proof of the prosecution in a criminal case, preponderance of the evidence, which is the burden of proof for the plaintiff in a civil case, and probable cause, which might not technically be burden of proof, but falls into the same category of stuff because it's the standard by which police need to show that most of the actions they could take in arresting somebody or interrogating somebody are justified based on the evidence they have at that point. Another police-specific burden of proof, as I'm calling it, which may or may not be correct, is reasonable articulable suspicion, which means that the police have a reasonable articulable suspicion that something shady is going on, and it's not just a hunch, they have like actual evidence or experience to back it up. Our next term is standard of review, which might sound similar or related to burden of proof, but it's really not. It actually has to do with the appeals process, which we touched on briefly at the beginning of this video. The standard of review is the amount of deference that the higher court gives the lower court in reviewing its judgment. There are 3 different standards of review. Reviewing de novo for questions of law, reviewing for clear error on questions of fact, and reviewing for abuse of discretion on matters of discretion. Next is a distinction that I think is pretty easy but was really confusing when no one explained it to me. And that is the difference between a brief, a motion, and an opinion. A motion is simply a request for the court to do something. Pretty common examples are motion for summary judgment or motion for dismissal. A brief, on the other hand, is the arguments and case law that is supporting that request in the motion. And then the opinion is a lot like a brief, except it's written by the court instead of one of the parties. It's their judgment, which becomes case law. In a civil case, that judgment, in addition to deciding liability, might consider damages, or alternatively, an injunction. Damages are assigned monetary compensation for some harm that the defendant presumably caused the plaintiff. So in a breach of contract case, if the plaintiff lost money because the defendant didn't follow through on the contract, the defendant has to pay the plaintiff that money. An injunction is what's called specific performance though, and instead of money, you're basically asking that the defendant does something or doesn't do something. I think it's usually the latter. So if it's a, nuisance case, you haven't necessarily been harmed, you aren't owed any money, but if your neighbor is making a ton of noise all the time that they're not allowed to make, the injunction is a court order to stop that. Next up is an affidavit, and maybe I should have put this in the section with brief and opinion and all that because it's still a written document. An affidavit is probably best thought of as equivalent to court testimony. You're writing something down, you're swearing that it's true, and it can be used as evidence in court to impeach you or to, introduce something else. It also can be used to back up something like a search warrant if it's written by a police officer. Next up is something that came up a lot in contract law and a little in property, and it took me so much longer than it should have to figure out what it meant. Intestate, which is not what it sounds like, is somebody who dies without a will. An executor is someone who's in charge of executing a written will. You also might see executrix, which is just the female version of executor. I don't know why we need 2 different words for that. If you see anything like estate, executor, anything like that, someone's died and they may or may not have had a will. Speaking of property, I have 2 quick terms for you. The first is chattel, which is any movable property. So not land or buildings, but if you have a couch or a phone or a car, that's all chattel. Curtilage is the land around a house and forming an enclosure of some kind around it. So your front yard, your backyard, even your garage, because it can include structures and buildings in that area outside of your house, is all considered curtilage. This matters because there are different rules for if police can go into your house without your permission versus your curtilage or where they can search, etc. Okay, I've got 2 more for you, and thankfully they're not that hard. The first one is remand. You'll see this in courts of appeals or Supreme Court opinions where at the very end it says, so ordered and remanded back to the lower court, or something like that. So you'll see this most often when a court didn't reach a decision about a certain question that the Court of Appeals finds to be relevant. Think about it kind of like a logic game. If you have question A, B, and C, and you only think about question A. You say question A is going to be a no, and so we don't even need to think about B and C. It goes up to the Court of Appeals and they say nope, question A should have been answered yes, and you need to consider question B and C to determine the outcome of the case. That's kind of what we're talking about here. It's hard to give a more specific example because it can vary so much from case to case, but remand basically just means that the Court of Appeals hasn't given a final judgment on the case. It's going to go back to the lower court to decide. My very last term of legalese for you is circuit courts, because I didn't understand how the American court system even worked, and I learned about it because a lot of people in law school talk about clerking on the 11th Circuit or the 1st Circuit, and I had no idea what they were talking about. So here's a map for your reference. Basically what you need to know is within the 50 states of the United States, there are 94 federal judicial districts, and those are organized into 12 regional circuits. Each circuit has its own court of appeals. And then there's also the federal circuit, which is the 13th Circuit. I think that all you really need to understand is this map that I just showed you, and to know that that's what people are talking about when they refer to the 1st or the 2nd or the 3rd Circuit. I know this video was more of a wide spread of information instead of a deep dive into any of it, but like I said, I was really confused when I started law school and didn't know any of these things, and even more so when no one explained them to me. So even having a cursory surface level understanding that these are concepts you're going to want to know and be able to talk about with at least some level of confidence, I think will put you ahead of the game. I'm always trying to prepare you guys more than I was prepared by the time that you start law school. And if you have any more questions about these concepts or anything else that you feel like you might want to know before you start, let me know in the comments below. I always love to hear from you, and I respond to as many comments as I can. If you liked this video and want to see more like it, let me know by hitting that thumbs up button and subscribing to this channel so you don't miss whenever I post. It really helps me out a lot and definitely would contribute to my goals for 2021. I look forward to seeing you guys next Saturday with another video if my phone holds out, because oh my gosh, it's been giving me trouble. But until then, God bless.